Now, let's see the provisions in Chapter 2 of the Companies Act 2013. Incorporation of company and matters incidental thereto. According to Section 3, formation of company. A company may be formed for any lawful purpose by 7 or more persons where the company to be formed is to be a public company. 2 or more persons where the company to be formed is to be a private company. Or 1 person where the company to be formed is to be 1 person company, that is to say, a private company. By subscribing their names or his name to a memorandum and complying with the requirements of this Act in respect of registration, provided that the memorandum of 1 person company shall indicate the name of the other person with his prior written consent in the prescribed form, who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company, and the written consent of such person shall also be filed with the registrar at the time of incorporation of the 1 person company along with its memorandum and articles. Provided further that such other person may withdraw his consent in such manner as may be prescribed. Provided also that it shall be the duty of the member of 1 person company to intimate the company the change, if any, in the name of other person nominated by him or by indicating in the memorandum or otherwise within such time and in such manner as may be prescribed. And the company shall intimate the registrar any such change within such time and in such manner as may be prescribed. Provided also that any such change in the name of the person shall not be deemed to be an alteration of the memorandum. A company formed under subsection 1 may be either a company limited by shares, a company limited by guarantee, or an unlimited company. Memorandum. According to Section 4, memorandum of a company shall state the name of the company with the last word limited in case of public limited company, or the last words private limited in case of a private limited company, provided that nothing in this clause shall apply to a company registered under Section 8. The state in which the registered office of the company is to be situated. The objects for which the company is proposed to be incorporated and any matter considered necessary in furtherance thereof. The liability of members of the company, whether limited or unlimited. And also state, in the case of a company limited by shares, liability of its members is limited to the amount unpaid, if any, on the shares held by them, and in case of a company limited by guarantee, the amount up to which each member undertakes to contribute to the assets of the company in the event of its being wound up while he is a member or within 1 year after he ceases to be a member, for payment of the debts and liabilities of the company or of such debts and liabilities as may have been contracted before he ceases to be a member, as the case may be, and to the cost, charge, and expenses of winding up and for adjournment of the rights of the contributories among themselves. In case of a company having a share capital, the amount of share capital with which the company is registered and the division thereof into shares of a fixed amount and the number of shares which the subscribers to the memorandum agree to subscribe, which shall not be less than 1 share, and the number of shares each subscriber to the memorandum intends to take indicated opposite his name. In the case of one-person company, the name of the person who, in the event of death of the subscriber, shall become member of the company. The name stated in the memorandum shall not be identical with or resemble too nearly to the name of an existing company registered under this Act or any previous company law. The name, identical name or resemblance in name is not allowed under the Companies Act, be such that its use by the company will constitute an offence under law for the time being in force or is undesirable in the opinion of the central government. The central government may not allow or don't desire such resemblance of names. Without prejudice to the provisions of subsection 2, a company shall not be registered with a name which contains any word or expression which is likely to give the impression that the company is in any way connected with or having the patronage of the central government, any state government, or any local authority, corporation or body constituted by the central government or any state government under any law for the time being in force. So there are certain words which should not be used in naming the companies. So the words which are connected to central government, state government and local authorities, corporations are not to be used in the name. Such word or expression as may be prescribed, unless the previous approval of the central government has been obtained for the use of such word or expression. A person may make an application in such form and manner and accompanied by such fee as may be prescribed to the registrar for the reservation of the name set out in the application as the name of the proposed company or the name to which the company proposes to change its name. Upon receipt of an application under subsection 4, the registrar may, on the basis of information and documents furnished along with the application, reserve the name for a period of 60 days from the date of the application. Whereafter reservation of name under clause 1, it is found that name was applied by furnishing wrong or incorrect information, then if a company has not been incorporated, the reserved name shall be cancelled and the person making application under subsection 4 shall be liable to a penalty which may extend to 1 lakh rupees. If the company has been incorporated, the registrar may, after giving the company an opportunity of being heard, either direct of the company to change its name within a period of 3 months after passing an ordinary resolution, take action for striking off the name of the company from the register of companies, or make a petition for winding up of the company. The memorandum of a company shall be respective forms specified in tables A, B, C, D and E in Schedule 1 as may be applicable to such company. Schedules are given as an annexure to the Act. In Schedule 1, Table A, B, C, D and E gives the template for memorandum of a company. Any provision in the memorandum or articles in the case of a company limited by guarantee and not having a share capital purporting to give any person a right to participate in the divisible profits of the company otherwise than a member shall be void. We saw what is memorandum. Memorandum gives us all the clauses which are associated with the external information about the company, whereas articles gives us the internal constituent of the management of the company. The articles of a company shall contain the regulations for management of the company. The article shall also contain such matters as may be prescribed, provided that nothing prescribed in this subsection shall be deemed to prevent a company from including such additional matters in its articles as may be considered necessary for its management. The articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if conditions or procedures or that are more restrictive than those applicable in the case of a special resolution are met or complied with. The provisions for entrenchment referred to in subsection 3 shall only be made either on formation of a company or by an amendment in the articles agreed to by all the members of the company in case of a private company and a special resolution in the case of a public company. Where the articles contain provisions for entrenchment, whether made on formation or by amendment, the company shall give notice to the registrar of such provisions in such form and manner as may be prescribed. The articles of a company shall be in respective form specified in tables F, G, H, I, and J in Schedule 1 as may be applicable to such company. A company may adopt all or any of the regulations contained in the model articles applicable in such company. In the case of any company which is registered after the commencement of this Act, insofar as the registered articles of such company do not exclude or modify the regulations contained in the model articles applicable to such company, those regulations shall, so far as applicable, be the regulations of that company in the same manner and to the extent as if they were contained in the duly registered articles of the company. Nothing in this section shall apply to the articles of a company registered under any previous company law unless amended under this Act. So, we learned that by referring Schedule 1, the various tables are given to draft the memorandum and a template to draft the articles of association. And memorandum gives us the provisions relating, company's provisions relating to the external environment, and the articles gives us all the provisions related to the internal environment and management activities. Act to override memorandum or articles, save as otherwise expressly provided in this Act. Override. So when the company has a valid memorandum of association and articles of association, how it can be overridden? The provisions of this Act shall have effect notwithstanding anything to the contrary contained in the memorandum or articles of a company, or in any agreement executed by it, or in any resolution passed by the company in general meeting or by its board of directors, whether the same be registered, executed, or passed, as the case may be, before or after the commencement of this Act. And any provision contained in the memorandum, articles, agreement, or resolution shall, to the extent to which it is repugnant to the provisions of the Act, become or be void as the case may be. Incorporation of company. According to section 7, there shall be filed with the registrar of companies within whose jurisdiction the registered office of a company is proposed to be situated following documents and information for registration, namely the memorandum and articles of the company duly signed by all the subscribers to the memorandum in such manner as may be prescribed, a declaration in the prescribed form by an advocate, chartered accountant, cost accountant, or company secretary in practice who is engaged in the formation of the company, or by a person named in the articles as the director, manager, secretary of the company, that all the requirements of this act and the rules made thereunder in respect of registration and matters precedent or incidental thereto have been complied with. So these are the list of documents which are to be attached with SPIC-E form. It includes memorandum of the company, articles of the company, a declaration in the prescribed form by an advocate, and it should be, the application form should be signed by all the subscribers, an affidavit from each of the subscribers to the memorandum and form from persons named as the first directors. So when a company is being incorporated for the first time, there will be the first set of directors, the first auditors, and certificate of incorporation may come, allotment of DIN number to the directors may happen, certificate of commencement of business needs to be done. So when attaching all the required documents to the SPIC-E form, incorporation application will be accepted by the MCA, and all need to create an account in the Ministry of Corporate Accounts, LLP to be registered in B2, and company related should be registered in B3. To the memorandum and from the persons named as the first directors, if any, in the articles that he is not convicted of any offence in connection with the promotion, formation or management of any company, or that he has not been found guilty of any fraud or misfeasance or any breach of duty to any company under this act or any previous company law during the preceding 5 years, and that all the documents filed with the registrar for registration of the company contain information that is correct and complete and true to the best of his knowledge and belief. So the information provided with the form application, incorporation application form, needs to be correct, complete, true to the best of his knowledge and belief. The address for correspondence till its registered office is established. The particulars of name, including surname or family name, residential address, nationality, and such other particulars of every subscriber to the memorandum, along with the proof of identity as may be prescribed in case of a subscriber being a body corporate, such particulars as may be prescribed. The particulars of the person mentioned in the articles as the first directors of the company, their names, including surname or family name, the DIN number, director identification number, residential address, nationality, other particulars including proof of identity as may be prescribed, and the particulars of the interest of the persons mentioned in the articles as the first directors of the company in other firm or bodies corporate, along with their consent to act as directors of the company in such form and manner as may be prescribed. The registrar, on the basis of documents and information filed under subsection 1, shall register all the documents and information referred to in that subsection in the register and issue a certificate of incorporation in the prescribed form to the effect that the proposed company is incorporated under the Act. On and from the date mentioned in the certificate of incorporation issued under subsection 2, the registrar shall allot to the company a corporate identification number, which shall be a distinct identity for the company and which shall also be included in the certificate. The company shall maintain and preserve at its registered office copies of all the documents and information as originally filed under subsection 1 till its dissolution under the Act. So one should keep in mind that a company needs to be incorporated under the Act. All the business activities should be properly intimated to the Registrar of Companies and the regulatory authorities as per the Companies Act. When they want to stop the business activities of a company, it should be properly winded up, or if there is any offense, you need to wind up due to some offense. You should dissolve the company properly under this Act. So the further provisions will give all the information about incorporation, conducting meetings, and how to conduct business under this Act, and how to keep the Registrar of Companies informed, and what are all the various information about the offences, penalties, the frauds, liabilities, etc., etc. So if any person furnishes any false or incorrect particulars of any information or suppresses any material information, so suppressing is not allowed, false and incorrect particulars are not allowed, of which he is aware in any of the documents filed with the registrar in relation to the registration of a company, he shall be liable for action under section 447 without prejudice to the provisions of subsection 5, where at any time after the incorporation of a company it is proved that the company has been incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by any fraudulent action, the promoters, the person named as the first directors of the company, and the person making declaration under clause B of subsection 1 shall each be liable for action under section 447 without prejudice to the provisions of subsection 6, where a company has been got incorporated by furnishing any false or incorrect information or representation, by suppressing any material fact or information in any documents or declaration filed or made for incorporating such company, or by any fraudulent action. The tribunal may, on an application made to it, on being satisfied that the situation so warrant, pass such orders as it may think fit. So, if you incorporate a company and by involving some fraudulent action, when it reaches the tribunal may issue warrant. Pass such orders as it may think fit for regulation of the management of the company, including changes, if any, in its memorandum and articles, in public interest or in the interest of the company and its members and creditors. Direct that liability of the members shall be unlimited, or direct removal of the name of the company from the registrar of companies, pass an order for the winding up of the company, pass such other orders as it may deem fit. So, provided that before making any order under this subsection, the company shall be given a reasonable opportunity of being heard in the matter. The tribunal shall take into consideration the transactions entered into by the company, including the obligations, if any, contracted, or payment of any liability. According to Section 8, formulation of companies with charitable objects, where it is proved to the satisfaction of the central government that a person or an association of persons proposed to be registered under this Act as a limited company has in its objects the promotion of commerce, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other object, intends to apply its profits, if any, or other income in promoting its objects, intends to prohibit the payment of dividend to its members. The central government may, by license issued in such manner as may be prescribed and on such conditions as it deems fit, allow that person or association of persons to be registered as a limited company under this section without the addition to its name of the word limited, or as the case may be, the words private limited, and thereupon the registrar shall, an application in the prescribed form, register such person or association of persons as a company under this section. A company registered under this section shall enjoy all the privileges and be subject to all the obligations of limited companies. A firm may be a member of the company registered under this section. A company registered under this section shall not alter the provisions of its memorandum or articles except with the previous approval of the central government. A company registered under this section may convert itself into a company of any other kind only after complying with such conditions as may be prescribed. Where it is proved to the satisfaction of the central government that a limited company registered under this Act or under any previous company law has been formed with any of the objects specified in Clause A of subsection 1 and with the restrictions and prohibitions as mentioned respectively in clauses B and C of that subsection, it may by license allow the company to be registered under this section subject to such conditions as the central government deems fit, and to change its name by omitting the word limited, or the case may be the words private limited from its name, and thereupon registrar shall on application in the prescribed form register such company under this section, and all the provisions of this section shall apply to that company. The central government may by order revoke the license granted to a company registered under this section if the company contravenes any of the requirements of this section, or any of the conditions subject to which a license is issued, or the affairs of the company are conducted fraudulently or in a manner violative of the objects of the company, or prejudicial to public interest, or without prejudice to any action against the company under this Act. Direct the company to convert its status and change its name to add the word limited or the words private limited, as the case may be, to its name, and thereupon the registrar shall, without prejudice to any action that may be taken under subsection 7 on application in the prescribed form, register the company accordingly, provided that no such order shall be made unless the company is given a reasonable opportunity of being heard. Provided further that the copy of every such order shall be given to the registrar. Where a license is revoked under subsection 6, The central government may by order, if it is satisfied that it is essential in the public interest, direct that the company be wound up under this act or amalgamated with another company registered under this section, provided that no such order shall be made unless the company is given a reasonable opportunity of being heard. Where a license is revoked under subsection 6 and where the central government is satisfied that it is essential in the public interest that the company registered under this section should be amalgamated with another company registered under this section and having similar objects, then notwithstanding anything to the contrary contained in the act, central government may by order provide for such amalgamation to form a single company with such constitution, properties, powers, rights, interest, authorities and privileges, and with such liabilities, duties and obligations as may be specified in the order. If on the winding up or dissolution of a company registered under this section, there remains, after the satisfaction of its debt and liabilities, any asset, they may be transferred to another company registered under this section and having similar objects subject to such conditions as the tribunal may impose, or may be sold and proceeds thereof credited to rehabilitation and insolvency fund formed under section 269. A company registered under this section shall amalgamate only with another company registered under this section and having similar objects. If a company makes any default in complying with any of the requirements laid down in this section, the company shall, without prejudice to any other action under the provisions of this section, be punishable with fine which shall not be less than 10 lakh rupees, but which may extend to 1 crore rupees. A fine, and the directors and every officer of the company who is in default shall be punishable with imprisonment which may extend to 3 years, or with fine which shall not be less than 25,000 rupees but which may extend to 25 lakh rupees, or with both. Provided that when it is proved that the affairs of the company were conducted fraudulently, every officer in default shall be liable for action under section 447. The effect of registration. From the date of incorporation mentioned in the certificate of incorporation, such subscribers to the memorandum and all other persons as may from time to time become members of the company shall be a body corporate by the name contained in the memorandum, capable of exercising all the functions of an incorporated company under this act, and having perpetual succession with power to acquire, hold and dispose of property both movable and immovable, tangible and intangible, to contract and to sue and be sued by the said name. Effect of Memorandum and Articles. Subject to the provisions of this Act, the Memorandum and Articles shall, when registered, bind the company and the members thereof to the same extent as if they were respectively had been signed by the company and by each member, and contained covenant on its and his part to observe all the provisions of the Memorandum and of the Articles. All monies payable by any member to the company under the Memorandum or Articles shall be a debt due from him to the company. Commencement of business. Registered Office of Company. A company shall, on and from the 15th day of its incorporation and at all times thereafter, have a registered office capable of receiving and acknowledging all communications and notice as may be addressed to it. So all the communications and notices will be sent to the registered office of the company. the company shall furnish to the registrar verification of its registered office within a period of 30 days. So within 15 days, the registered office should be capable of receiving all the communications and correspondences, and the company shall furnish to the registrar verification of its registered office within a period of 30 days of its incorporation and in such manner as may be prescribed. Every company shall paint or affix its name, address of its registered office, and keep the same painted on the outside of every office or place in which its business is carried on in a conspicuous position, in legible letters. Characters employed thereof are not those of the language or of one of the languages in general use in that locality, also in the characters of that language or of one of those languages. Have its name engraved in legible characters. Name engraved in legible characters on its seal. Get its name, address of its registered office and the corporate identity number along with the telephone number, fax number, if any, email and website address, if any, printed in all its business letters, billheads, letter papers and in all its notices and other official publications, and have its name printed on hundis, promissory notes, bill of exchange and such other documents as may be prescribed. Provided that where a company has changed its name or names during the last 2 years, it shall paint or affix or print as the case may be along with the name, the former name or name so changed during the last 2 years as required under clauses A and C. Provided further that the words one person company shall be mentioned in brackets below the name of such company where its name is printed, affixed and engraved. So the name of the company should be printed, affixed or engraved despite the nature of company. Notice of every change of the situation of the registered office, verified in the manner prescribed after the date of incorporation of the company, shall be given to the registrar within 15 days of the change, who shall record the same. The registrar of companies record all the changes, updates of the company, except on the authority of a special resolution passed by a company. The registered office shall not be changed. So when a company changes its registered office, it should pass a special resolution after conducting extraordinary general meeting, and then it should change the registered office. In the case of an existing company outside the local limits of any city, town or village, where such office is situated at the commencement of this act and where it may be situated later by virtue of a special resolution passed by the company. In the case of any other company outside the local limits of any city, town or village where such office is first situated or when it may be situated later by virtue of a special resolution passed by the company. Provided that no company shall change the place of its registered office from the jurisdiction of one registrar to the jurisdiction of another registrar within the same state unless such change is confirmed by the regional director on an application made in this behalf by the company in the prescribed manner. The confirmation referred to in subsection 5 shall be communicated within a period of 30 days from the date of receipt of application by the regional director to the company, and the company shall find the confirmation with the registrar within a period of 60 days of the date of confirmation, who shall register the same and certify the registration within a period of 30 days from the day of filing of such confirmation. The certificate referred to in subsection 6 shall be conclusive evidence that all requirements of the Act with respect to change of registered office in pursuance of subsection 5 have been complied with, and the change shall take effect from the date of the certificate. If any default is made in complying with the requirements of this section, the company and every officer who is in default shall be liable to a penalty of 1,000 rupees for every day during which the default continues, but not exceeding 1 lakh rupees. Alteration of memorandum. According to section 13, Section 61, a company may by a special resolution and after complying with the procedures specified in this section alter the provisions of its memorandum. Any change in the name of a company shall be subject to the provisions of subsections 2 and 3 of section 4 and shall not have effect except with the approval of the central government in writing, provided that no such approval shall be necessary where the only change in the name of the company is the deletion therefrom or addition thereto of the word private, consequent on the conversion of any one class of companies to another class in accordance with the provisions of this Act. When any change in the name of the company is made under subsection 2, the registrar shall enter the new name in the register of companies in place of the old name and issue a fresh certificate of incorporation with the new name. So the old name will be removed and they will issue a fresh certificate of incorporation with the new name. The change in the name shall be complete and effective only on the issue of such certificate. The alteration of the memorandum relating to the place of its registered office from one state to another shall not have any effect unless it is approved by the central government on an application in such form and the manner may be prescribed. The central government shall dispose of the application under subsection 4 within a period of 60 days and before passing its order may satisfy itself that the alteration has the consent of the creditors, debenture holders and other persons concerned with the company, or that the sufficient provision has been made by the company either for due discharge of all its debts and obligations, or that adequate security has been provided for such discharge, save as provided in section 64. A company shall, in relation to any alteration of its memorandum, file with the registrar the special resolution passed by the company under subsection 1, the approval of the central government under subsection 2 if the alteration involves any change in the name of the company. Where an alteration of the memorandum results in the transfer of the registered office of a company from one state to another, a certified copy of the order of the central government approving the alteration shall be filed by the company with the registrar of each state within such time and in such manner as may be prescribed, who shall register the same. The registrar of the state where the registered office is being shifted to shall issue a fresh certificate of incorporation indicating the alteration. A company which has raised money from public through prospectus and still has not any unutilized amount of the money so raised shall not change its objects for which it raised the money through prospectus unless a special resolution is passed by the company, and the details as may be prescribed in respect of such resolution shall also be published in the newspapers, one in English and one in vernacular language, which is in circulation at the place where the registered office of the company is situated, and shall also be placed on the website of the company, if any, indicating therein the justification for such change. The dissenting shareholders shall be given an opportunity to exit by the promoters and shareholders having control in accordance with regulations to be specified by the Securities and Exchange Board. The registrar shall register any alteration of the memorandum with respect to the objects of the company and certify the registration within a period of 30 days from the date of filing of the special resolution in accordance with Clause A of subsection 6 of this section. No alteration made under this section shall have any effect until it has been registered in accordance with the provisions of this section. Any alteration of the memorandum in the case of a company limited by guarantee and not having a share capital, purporting to give any person a right to participate in the divisible profits of the company otherwise than as a member shall be void. Now let's look at the alteration of articles. So far we studied all the provisions relating to the alteration of memorandum of a company. Now, according to section 14, alteration of articles. Subject to the provisions of this Act and the conditions contained in its memorandum, if any, a company may by a special resolution alter its articles, including alterations having the effect of conversion of a private company into a public company or a public company into a private company, provided that where a company being a private company alters its articles in such a manner that they no longer include restrictions and limitations which are required to be included in the articles of a private company under this Act. The company shall, as from the date of such alteration, cease to be a private company. Provided further that any alteration having the effect of conversion of a public company into a private company shall not take effect except with the approval of the tribunal, which shall make such order as it may deem fit. So the tribunal has to agree when it comes to conversion of a public limited company to a private company. Every alteration of the articles under this section and a copy of the order of the tribunal approving the alteration as per subsection 1 shall be filed with the registrar together with a printed copy of altered articles within a period of 15 days in such a manner as may be prescribed, who shall register the same. Any alteration of the articles registered under subsection 2 shall, subject to the provisions of this Act, be valid as if it were originally in the articles. Alteration of memorandum or articles to be noted in every copy. Every alteration made in the memorandum or articles of a company shall be noted in every copy of the memorandum or articles, as the case may be. If a company makes any default in complying with the provisions, a company and every officer who is in default shall be liable to a penalty of 1,000 rupees for every copy of the memorandum articles issued without such alteration. So if the company does not make the necessary changes in the memorandum and articles, so the officer in default is liable to a penalty of 1,000 rupees for every copy of memorandum or articles issued without such alteration. Rectification of name of company. If through inadvertence or otherwise a company on its first registration or on its registration by a new name is registered by a name which, in the opinion of the central government, is identical with or too nearly resembles the name by which a company in existence had been previously registered, whether under this Act or any previous Act, it may defer the company to change its name. It may direct the company to change its name, and the company shall change its name. The central government may direct the company to change the name when it finds out identical names of the company. Such change, as the case may be, within a period of 3 months from the issue of such direction after adopting an ordinary resolution for the purpose. So, when central government looks the name and if it finds identical names, it may issue an order to change or a direction to change. The company should change within 3 months by passing an ordinary resolution. There is no need to pass a special resolution. An ordinary resolution for the purpose is enough. On an application by a registered proprietor of a trademark, name is identical with or too nearly resembles registered trademark of such proprietor under the Trademarks Act 1999 made to the central government within 3 years of incorporation or registration or change of name of the company where under this act or any previous company law in the opinion of the central government is identical with or too nearly resembles to an existing trademark. It may direct the company to change its name, and the company shall change its name or new name, as the case may be, within a period of 6 months from the issue of such direction, after adopting an ordinary resolution for the purpose. Where a company changes its name or obtains a new name under subsection 1, it shall within a period of 15 days from the date of such change give notice of the change to the registrar along with the order of the central government. So we should keep in mind, when the names are identical and it will be found out by the central government may issue directions to the company. After getting such directions, the company need to update the same, giving notice of change to the registrar of companies along with the order of the central government, who shall carry out necessary changes in the certificate of incorporation and memorandum. If a company makes default in complying with any direction given under subsection 1, the company shall be punishable with a fine of 2,000 rupees for every day during which the default continues, and every officer who is in default shall be punishable with a fine which shall not be less than 5,000 rupees but which may extend to 1 lakh. Copies of memorandum, articles, etc. to be given to members. A company shall, on being so requested by a member, send to him within 7 days of the request, subject to the payment of such fees as may be prescribed, a copy of each of the following documents, namely the memorandum, the articles, every agreement and every resolution referred to in subsection 1 of section 117, if and in so far as they have not been embodied in the memorandum or articles. If a company makes a default in complying with the provisions of this section, a company and every officer of the company who is in default shall be liable for such default to a penalty of 1,000 rupees for each day during which such default continues, or 1 lakh rupees whichever is less. Conversion of companies already registered. According to section 18, a company of any class registered under this act may convert itself as a company of other class under this act by alteration of memorandum and articles of the company in accordance with the provisions of this chapter. Where the conversion is required to be done under this section, the registrar shall, on application made by the company, after satisfying himself that the provisions of the chapter applicable for registration of companies have been complied with, close the former registration of the company, and after registering the documents referred to in subsection 1, issue a certificate of incorporation in the same manner as its first registration. The registration of a company under this section shall not affect any debt, liabilities, obligations, or contracts incurred or entered into by on behalf of the company before conversion, and such debt, liabilities, obligations, and contracts may be enforced in the manner as if such registration has not been done. Subsidiary company not to hold shares in its holding company. According to section 18 in chapter 2, no company shall either by itself or through its nominees hold any shares in the holding company, and no holding company shall allot or transfer shares to any of its subsidiary companies, or any such allotment or transfer of shares to its subsidiaries shall be void. The holding company may hold 51% of shares in its subsidiaries and subsidiary company, whereas subsidiary company is not allowed to hold any shares of the holding company, provided nothing in this subsection shall apply to a case where the subsidiary company holds such shares as the legal representative of a deceased member of the holding company, where the subsidiary company holds such shares as a trustee, where the subsidiary company is a shareholder even before it became a subsidiary company. Subsidiary company is a shareholder before it became a subsidiary of the holding company. Provided further that the subsidiary company referred to in the preceding proviso shall have a right to vote at a meeting of the holding company only in respect of the shares held by its legal representative or as a trustee as referred to in clause A or clause B of the said provision. The reference in this section of a holding company, which is a company limited by guarantee or an unlimited company not having a share capital, shall be construed as a reference to the interest of its members, whatever be the form of interest. Service of documents. A document may be served on a company or an officer thereof by sending it to the company and the officer at the registered office of the company by registered post or by speed post or by courier service, or by leaving at its registered office by means of such electronic or other mode as may be prescribed, provided that where securities are held with a depository, the records of beneficial ownership may be served with such depository on the company by means of electronic or other mode, save as provided in this Act or the rules made thereunder for filing of documents with the registrar in electronic mode. A document may be served on registrar or any member by sending it to him by post or by registered post or by speed post or by courier or by delivering at his office or address or by such electronic or other mode as may be prescribed, provided that a member may request for delivery of any document through a particular mode for which he shall pay such fees as may be determined by the company in its annual general meeting. For the purpose of this section, the term courier means a person or agency which delivers a document and provides proof of its delivery. We explained the term courier in the Companies Act. Authentication of documents, proceedings and contracts. According to section 21, save or otherwise provided in this Act, a document or proceeding requiring authentication by a company or the contracts made by or on behalf of a company may be signed by any key managerial personnel or an officer of the company duly authorized by the board in this behalf. Execution of bills of exchange. A bill of exchange, hundi or promissory note, shall be deemed to have been made, accepted, drawn or endorsed on behalf of a company if made, accepted, drawn or endorsed in the name of or on behalf or an account of the company by any person acting under its authority, express or implied. A company may, by writing under its common seal, if any, authorize any person either generally or in respect of any specified matters as its attorney to execute other deeds on its behalf in any place either in or outside India, provided that in the case of a company does not have a common seal, the authorization under this subsection shall be made by two directors or by a director and a company secretary. So if there is no common seal, if you don't have a common seal, two directors or by a director and the company secretary, wherever the company has appointed a company secretary, can sign the bill. A deed signed by such an attorney on behalf of the company and under this seal shall bind the company. So chapter 2 is over. In the next video we can study chapter 3, the provisions which fall under the chapter 3 about prospectus and allotment of securities. Thank you.